Hello, I'm Ben Jones. I'm a partner in the BLM London Catastrophic Injury Team dealing with EL and PL claims. And I've been doing railway claims for over 10 years now. I'm here today with Peter James, who's the head of the Safety, Health and Environment team in London and has more than 20 years of experience in dealing with investigations and prosecutions, and himself is regularly involved in regulatory investigations involving accidents on the railway. We're going to be considering in this vlog 3 prosecutions within the last 10 years against railway industry parties where there's been a trespass onto their property and the trespasser has sustained serious or fatal injury whilst on the premises. Now, we appreciate the incidents we will be discussing were tragic, and we are not here to pass any judgment on the individuals or indeed the companies involved, but rather to look at the reasons why 3 incidents with very similar circumstances resulted in 3 quite differing levels of fine. Now, the catalyst for the discussion today was the prosecution earlier this year of WH Malcolm Limited, which was fined £6.5 million after the tragic death of an 11-year-old boy who gained access onto the Daventry International Rail Freight Terminal, which was operated by WH Malcolm, to retrieve a football. The boy climbed onto the top of a stationary freight wagon where he received a fatal electrical shock from the overhead lines. Similarly, in 2014, DB Cargo was fined £2.7 million after a 13-year-old boy and 3 of his friends gained access into its railway yard. And again, one of the boys climbed onto the top of a freight train that was stationed under live overhead power lines. He received an electric shock and suffered life-changing injuries. In 2012, English, Welsh and Scottish Railways International, EWSI, was fined £180,000 following the death of a 13-year-old boy and serious injury to 2 14-year-old boys who had gained access to an abandoned depot through a gap in the boundary fence. Again, they had climbed onto an abandoned train beneath a live overhead wire, and one of the boys was electrocuted while his 2 friends suffered severe burns. So as I said, without trivializing or ignoring what are obviously very serious and sad events, there are some interesting issues to learn from these 3 prosecutions that explain why there were 3 quite different results in terms of the level of fine. So Peter and I are going to discuss those today. Perhaps the best place to start then, Peter, are the sentencing guidelines. What changes have there been and what has been the general result of this?
Yes, thank you, Ben. The sentencing guidelines for health and safety offences, corporate manslaughter and food safety offences apply to all organisations and offenders sentenced on or after the 1st of February 2016. That's regardless of the date of the actual offence. One of the intentions of the Sentencing Council that issued these guidelines was to provide consistency in the approach to sentencing health and safety offences. Fines should be proportionate to the seriousness of the offence, but also importantly to the size of the offending organisation. The Sentencing Council anticipated that more serious offences committed by larger organisations would result in higher levels of fines. The Sentencing Council conducted an impact assessment of the guidelines in 2019. It found that fines had increased for all sizes of organisations, but for large and very large organisations, the median fine had increased from £25,000 to £370,000. Fines over £1 million are now commonplace under the guidelines, and here we have a couple of examples. Now, the sentencing of English, Welsh and Scottish Railways took place prior to the introduction of the current guidelines. DB Cargo and WH Malcolm were fined under the guidelines. All 3 companies were prosecuted for similar offences, each involving the deaths or serious injury to children who were electrocuted after gaining entry to railway yards and depots. As can be seen, there has been a clear and dramatic increase in the levels of fines as a result of the guidelines.
Okay, so how do the current guidelines differ from previous practice?
The guidelines follow a new model based upon culpability of the offender, the seriousness of the harm risked, the likelihood of the harm risked occurring, and the harm actually caused by the offence. The guidelines suggest a starting point and range for the appropriate fine, taking into account culpability and harm, but linked to the turnover of the organisation. Organisations are categorised as very large, large, medium, small or micro, depending upon their turnover. So under the guidelines, large and very large organisations face much larger fines than smaller companies for similar offences, although there have been increases across the board.
Okay. With WH Malcolm and DB Cargo, those companies are of a similar size. So what factors might have accounted for the fine WH Malcolm received being nearly 2.5 times the size of the fine DB Cargo received?
Both companies had turnovers of over 200 million. They fell within the category of large organisations and were therefore facing much larger fines than, let's say, organisations with a turnover of less than 50 million, which is the starting point for large companies. Both could have been categorised as very large companies with the potential for much higher fines, and interestingly, the judge in DB Cargo, while not elevating the company to the category of a very large company, did take into account its significant size and increase the starting point of the fine. Each case will be considered on its own merits, and there were a number of specific factors in the WH Malcolm case that resulted in a much larger fine. We should also keep in mind the company is appealing that fine. The judge found that culpability of the company was high and the harm risked was death or life-changing injury with a very high likelihood of that harm occurring. In view of the numbers exposed to risk on the day, the deceased was in the company of 5 other boys who all went onto the track with him, and the offence being a significant cause of the harm, the judge decided to move up a harm category to one of very high culpability. The fact that the offence had resulted in a death was a particular factor. The judge also took into account the number of aggravating features, including the enforcement history of the company, demonstrating a pattern of failures to keep people safe. In 2004, an employee died when a trench collapsed due to inadequate safety management.
Okay, so what impact is pleading guilty going to have on the sentencing?
Well, as a rule, where an offender pleads guilty on the first occasion, now that's usually going to be when it appears for the first time in the magistrate's court, it is entitled to a discount of 1/3 from the fine. Both WH Malcolm and DB Cargo contested the prosecutions and did not receive a discount. Now that discount is going to be significant where an organisation is facing a fine running into the millions. In comparison, EWSI pleaded guilty to the offence charged and was given a discount.
Yes, well, I'm sure defendants and their insurers will be mindful of the impacts that a guilty plea in the criminal prosecution may have on any civil claim that might follow. As we know, though, Section 69 of the Enterprise Act removes any civil liability arising from a breach of the Health and Safety at Work Act. So it does not necessarily flow that a guilty plea in the criminal prosecution prejudices any civil claim that will follow. And looking at these 3 cases in particular, the duty owed under the Occupiers Liability Act 1984 to trespassers is very prescribed and distinct from any duty owed under the Health and Safety at Work Act.
It's also worth noting that where a defendant pleads guilty, it will often be on the basis that it accepts some, but not all the failings alleged by the prosecution. Now, this can leave open the possibility of defending the claim, but also making allegations of contributory negligence.
Okay, so how important is culpability in the sentencing process?
Well, assessing culpability is step 1 in the process of determining the seriousness of the offence. The guidelines provide different categories of culpability. These range from very high to high, medium and low. Now, what do these mean? Very high culpability will apply where there's been a deliberate breach or flagrant disregard of the law. This is reserved for the most serious breaches. High culpability is where an offender fell far short of the appropriate standard, for example, by failing to put in measures that are recognised standards in industry, ignoring concern raised by employees, failing to make appropriate changes following prior incidents, and following breaches, allowing breaches to subsist over a period of time. High culpability appears to be the default position for the HSE and ORR in many health and safety prosecutions. Medium culpability is typically found where systems were in place, but they were not sufficiently adhered to or implemented. And low culpability is where an offender did not fall far short of the appropriate standard. These are minor failings that occurred as isolated incidents.
Okay, and does the extent of the injury suffered by the party on the premises or involved have an impact on the sentence?
Yes, it's clear from the W.H. Malcolm sentence and earlier cases that a fatality will have a significant impact. Now, although the sentencing guidelines are based upon the risk of harm, a resulting fatality or serious injury will be viewed as a very serious aggravating feature, resulting in a higher fine where the death or serious injury were caused by the breach.
Right. So where there have been similar incidents within an industry, does that impact on sentencing, or perhaps if an organisation has prior convictions as well?
While courts will assess each case on its own merits and should not treat previous penalties in similar cases as authorities, the fact there's been similar incidents and prosecutions within an industry could be taken into account when considering culpability. Now, culpability will take into account a failure to put in place measures that are recognised standards within the industry and ignoring concerns raised by employees or others. Where standards have changed or improved following previous incidents and convictions, a failure to adopt those standards will be an important factor when considering the seriousness of the offence. And of course, where an offending company has previous convictions for health and safety offences, this will be a serious aggravating feature.
Okay, so finally, Peter, what can we expect if there is another prosecution with a similar factual matrix?
Well, potentially, this could result in a much higher fine. One of the public interest arguments for bringing prosecutions is to get across to employers and duty holders the importance of health and safety management and the consequences of failing to ensure, so far as reasonably practicable, the safety of employees and the public who may be affected by the undertaking. Failure to take heed of lessons from these earlier cases could result in a finding of very high culpability, with those offences characterised as a deliberate breach or flagrant disregard of health and safety law.
Great. Okay. Well, thank you very much, Peter. We hope that was useful for you. And if you do have any questions or anything you would like to discuss with Peter or myself, then please do get in touch using the details provided. Thank you.
Thank you.